Tonight, a serious debate inside the Senate of Canada is raising important questions about the country's immigration system. In this video, you are about to watch a real discussion between Canadian lawmakers about asylum claims, international students, and a proposed rule that could change how some claims are handled. During this debate, a senator presents a very real scenario. What if someone comes to Canada as an international student, studies for years, and later files an asylum claim? Should they still be allowed to apply? Or should there be a time limit? The video you are about to watch shows the exact question being asked and the government's response. This is a real parliamentary discussion that most Canadians never get to see. And what is said in this debate could raise serious questions about how the immigration system is being shaped right now.
In your opening remarks, you mentioned, if I have this correct, 17% of asylum claims came from students.
And next you will see and hear. A serious question is raised during a debate in the Senate of Canada. The discussion is about a proposed rule under Bill C-12, a rule that could place a one-year limit on certain asylum claims. But the scenario presented here is something many people may not have thought about. Imagine a person who comes to Canada as an international student. They are studying at a recognized university, building their future and living in the country for several years. But during their time in Canada, they openly reveal their sexual orientation. Now, the question being raised in the Senate is very direct. If this person comes forward after the one-year period, would they be prevented from even making an asylum claim? Could a time limit stop their case from reaching the Immigration and Refugee Board? This is the exact concern being put forward in the debate. And in the next clip, you will hear the question as it is asked directly inside the Senate.
So you may have an individual who's been here as an international student at a recognized post-secondary institution, let's say doing a 4-year degree. And as part of their studies, they come out in the second year as LGBTQ. So under the one-year rule that is proposed under C-12, would this person not be prevented from putting in an asylum claim in the Immigration Refugee Board because they've come out after the one-year period, which could, if they were removed?
If someone misses the one-year asylum deadline, does the system still give them another chance to stay in Canada? And next, you will hear the government response to the question raised earlier about the one-year rule. The answer given is clear. Even if the deadline passes, the person would not automatically become ineligible. This means there is still another process in the system that can review their case. But this response immediately opens a new concern in the Senate. If another process is responsible for reviewing these serious claims, then who is making those decisions and how prepared are they? The discussion now shifts toward the training and experience of the individuals handling such complex asylum cases. Major points from the debate. Canada's immigration system does not operate through a single decision point. Even when one path closes, other legal processes may still review a person's case, which can extend how long someone remains in the system. The role of decision makers. Asylum cases often involve international human rights law, country risk assessments, and legal interpretations, system pressure, and case backlogs. When multiple processes exist for the same type of case, it can increase the number of files being reviewed by different authorities.
So it's an excellent question. No, they would still be eligible. That's part of the PRRA process, so they would not automatically be ineligible.
So with the PRRA process, we've heard that some of the individuals have only 6 months of training.
Can a new law conflict with the existing guidelines used to protect refugee claimants in Canada? Next, you will hear. A serious concern is raised about a possible contradiction in the system. The senator explains that some people may delay filing an asylum claim for very personal and sensitive reasons, especially when it involves sexual orientation or gender identity. The argument presented here is that existing guidelines from the Immigration and Refugee Board already recognize that people may need time before they feel safe enough to come forward. But if a strict one-year limit is applied, it could create a direct conflict between the new legislation and the current guidelines used in refugee cases. Major points from the debate. IRB guidelines already recognize that some refugee claims may be delayed for personal safety reasons. A strict time limit could conflict with existing refugee protection guidelines. Many claimants may delay disclosing their identity due to fear of family or community reprisal. Contradictions between policy and legislation can create legal challenges in the immigration system.
An individual may reasonably delay making a claim for refugee protection based on their sexual orientation, gender identity, etc., out of a fear of reprisal for themselves or family members. A reasonable delay may also arise out of their reluctance to reveal their sexual orientation, gender identity to a spouse, family member. So we seem to have a direct contradiction to what this legislation is proposing and what the IRB guideline number 9 states.
If the law creates a problem, can exception and regulations fix it later? In this part of the debate, the government responds to the concern about possible contradictions in the law. The explanation given is that the pre-removal risk assessment process, also known as PRRA, can be used to review these situations before someone is removed from Canada. The response also points out that exceptions can be added through regulations. In other words, even if the legislation sets certain limits, additional rules can be created to handle special cases. This part of the debate shows how government processes may rely on both legislation and regulations to deal with complex immigration situations. Major points from the debate. PRRA is a legal process used to assess risk before someone is removed from Canada. Regulations can create exceptions even after a law is passed. Immigration decisions often involve multiple layers of review. Policy flexibility is sometimes used to handle complex or sensitive cases.
Again, the PRRA, the pre-removal risk assessment process, would be able to, based on the legislation we've drafted and based on the fact that in regulations we are able to put exceptions, and those are being worked on as well, we would be able to deal with those scenarios.
What happens if a policy says one thing, but the law itself says something different? In this part of the debate, a very important legal issue is raised. The senator points out that even if policies try to handle certain cases, the real authority always comes from the legislation. In simple terms, the law is supreme, and policies can only interpret what the law allows. This is why a direct question is asked. Should there be a clear exemption written into the legislation for claims related to sexual orientation or gender identity that may be made after the one-year period? The government response suggests that these situations will still be reviewed through legal processes and country risk assessments. Major points from the debate. Legislation always has the highest authority in the legal system. In Canada's legal framework, laws passed by Parliament override internal policies or guidelines. Government policies are used to guide how officials apply the law, but they cannot change the legal limits set by legislation. When special circumstances are written directly into legislation, it reduces uncertainty for both claimants and decision-makers. When reviewing asylum or protection claims, authorities often examine conditions in the person's home country. This includes human rights conditions, safety risks, and whether returning the person could put them in danger.
So being able to deal with them through policy, but having a contradiction through legislation can be a problem, right? The legislation is supreme. The policy interprets the legislation. So would the federal government be open to an exemption based on sexual orientation, gender identity claims put into the legislation that occur beyond 1 year?
That is part of our laws, and that is part of our natural justice and so the process will look at those and will look at countries. And
what if some people cannot be deported, even after their claim is declared ineligible? In this final part of the debate, the government explains that immigration decisions are not based on a single law alone. Many other legal factors also play a role, including court decisions, human rights protections, and Canada's Charter of Rights. The response also points out that for some countries, Canada already has deferral orders in place. This means even if a person is ruled ineligible, they may still not be deported because of safety risks or legal protections. The government argues that these different legal layers are meant to ensure protection in complex cases. Major points from the debate. In certain situations, Canada may place deferral orders on specific countries where conditions are considered too dangerous. This means even if a person loses their case, removal may not happen immediately. Immigration policy does not work in isolation. Decisions can also be influenced by the Charter of Rights, court rulings, and international human rights obligations. Canadian courts often review immigration laws and their application. When courts interpret these laws, their decisions can affect how government policies are implemented. In some cases, individuals may still receive protection through other legal processes, risk assessments, or court reviews before any final removal decision is made.
Many countries that already have a deferral order in place. So many of those countries we can't deport people even if they are ruled ineligible. So it's not just this legislation. We also have to work with it, with our with other legislation, with natural justice, with our charter rights and protection, with what courts have said. So we believe that there will be protection.
In this video, we followed a real discussion from the Senate that raised important questions about Canada's asylum system. The debate started with a scenario involving an international student and the proposed one-year limit on asylum claims. From there, senators and government representatives discussed how different processes, legal guidelines, and human rights protections interact with that rule. We also heard concerns about possible contradictions between legislation and existing guidelines, the role of different immigration processes, and how courts, the Charter of Rights, and country conditions can all affect final decisions. These are details that many people never get to see because they come from real parliamentary discussions and legal debates inside Canada's government. If you want more breakdowns like this and the latest updates on immigration news, Canada current affairs, and more Senate and parliamentary analysis, make sure to subscribe to Canada Insight Network.